There was almost a mistrial on day 6 of the KSoo trial, and I'm not a lawyer, but let me tell you why. So it actually started on day 5. The state was getting close to resting their case, and Hakeem Robinson's attorney casually throws out the names of a few people that they are planning to call to testify. The state objects to this because the defense never gave them a witness list, so they had no idea these people were going to testify. And that also means that the state never got the chance to depose them or question them regarding what they're going to testify about.
The other issue is, to date, the defense has still not listed any witnesses. Now, I'm not going to ask for to strike witnesses if they're on our witness list and we know what they're going to testify to. But there are the witness he just referenced that is in Europe, and then all these impeachment witnesses, they've never been listed. We have no idea who they are. And we would move to strike all of those witnesses as Richardson violations.
Okay. Have any of those witnesses, Mr. DeCoste, been disclosed in discovery to the state?
They're literally listed in the witness list for the Arthur hearing. Donnie Shipes, the sister testified. His mother is listed as a witness, Ebony.
It's hard to hear because Hakeem's attorney refuses to use the microphone. But basically, his argument is that because Hakeem's mom, sister, and manager were listed as witnesses in his bond hearing 3 years ago, the state shouldn't be surprised that they are going to be called. I guess. Now, the problem with that is that before the trial started, the defense requested the rule of sequestration, which means that anyone who's going to testify in this trial cannot sit in the courtroom to watch the trial or watch any of the live streams at home, because it could cause them to adjust their testimony based on what they've heard or seen. And as you can imagine, KSoo's mom and sister have been attending the trial in person, so it's a bit of a problem that the defense now wants to call them as witnesses.
And you all invoke the rule. So my question is, who of the folks who've been sitting in court watching this trial since the beginning are you intending to call, and how do I allow them to testify since they've been in here since the beginning watching the trial, and you all invoke the rule which would prevent any witnesses from being in here and watching the trial?
On this, it's either it's a person or not. There's no coloring the testimony. If we ask a question, looking at that video, is that consistent with Hakeem Robinson's height and weight at that time? It's a yes or no question.
Now, according to the defense, the reason they are making this last-minute decision to call these people to testify is because they never thought the judge was going to allow Hakeem's dad, Abdul Robinson Sr., to identify him in the video surveillance. Hakeem's attorney argues that only experts or people actually at the scene of a crime are allowed to identify people on video surveillance. So he says he was very surprised when the judge allowed Abdul Sr. to do it.
Because our position is no witness is allowed to comment on a video unless they were present at the time, which he wasn't, or an expert. And so I said, sidebar, turn to Mr. Cooper, and it's on the record, in the event that you elicit this testimony, we have a whole bunch of people, including them, that would be called to impeach his testimony. They opened this door by eliciting that testimony, and we, by law, have a right to rebut it.
Don't you have to provide the names of the witnesses you intend to call to the opposing party? Let me ask this question, because you did depose Abdul Sr., and in his deposition, whenever that was years ago, he identified his son as being in the video. Yes or no?
Yes.
Okay. So if you were intending then to call another family member to look at the video and say, no, that's not him, wouldn't you have known to do that at the time that you deposed Abdul Sr.? And if so, why wouldn't you have listed that person?
Your Honor, the answer to that is no. I was fully confident, without any doubt, that that would not be admitted because the case law is clear that a witness has to be either an expert or be present. I've never had a witness be allowed to comment on the identity of the person in the video unless they fit the strict parameters of the case law.
I'm going to take this under advisement, mind you. I'm not ruling right now. I will give you all the opportunity to find whatever case law you want, since no one has cited me anything at this point, to say that witnesses that you are calling at trial don't have to be disclosed to the opposing party.
So now you have the context, because this issue carries over to day 6.
You're saying Mr. Shipes was listed for a bond hearing. You would acknowledge he was not listed as a Category A witnesses for purposes of trial. And Ms. Robinson was not listed at all in any way, shape, or form during the 5-year pendency of this case. I will also add in there that my trial orders that I have entered throughout the pendency of this 5-year case, first done in February of 2023 and most recently done on February 19 of 25, also requires the parties to provide to the court the list of witnesses that might possibly testify. So I could read those names out to the jurors to see if any of the jurors are related by blood or marriage to the witnesses or have any business or social relationships with them. And I read out this complete list of names. And I asked the state, I asked Defendant Whitaker, I asked Defendant Robinson, are there any other names? You would acknowledge that Mr. Shipe's name and Ms. Robinson's name were not read. Okay.
The judge also explains that the law does allow for people beyond just experts or people present at the scene of a crime to identify people in videos.
And I ruled then, explaining, of course, that the law allows somebody who is familiar with the subject to look at a video or a photograph and identify the subject. So are you telling me that the court's ruling was a surprise that this was going to happen? Because I know you all have deposed Abdul Sr., I think the first time in 23, so over 2 years ago, and then again in 24. He was deposed twice, was he not? He was. Okay. And testified that he would be identified or would be identifying his son in the video. So that could not have been a surprise, because let me just say this, you all are smart lawyers, but you all know the case law. And 2nd DCA, 3rd DCA, 4th DCA, 5th DCA have all said that a witness can identify someone from the video. It does not invade the province of the jury. There have been cases where police officers have been able to identify. Parking security guards have been able to identify in video or in photographs if the predicate can be laid that they are familiar with the person, that they know the person, that they have some special relationship with the person that maybe a common person or a juror seeing it for the first time would not have. And that's especially true in cases in which the video or the photograph are not clear or don't particularly show the individual. This is what we're going to do. Then we're going to take a recess, and I'm going to ask the state to make its best efforts at deposing these 2 witnesses. Ask whatever questions you want to ask of them. Take however long you want to take with them. We will have to recess these 2 juries. They will just be sitting in their jury rooms waiting. And then let me hear from you if you have obtained whatever sufficient information you think you have. I'll hear further argument on prejudice, and then I'll make my decision.
So the state gets the opportunity to question these witnesses, and even after they do so, they still argue to the judge that the situation is unfair and the witnesses should not be allowed to testify. But ultimately, the judge decides that she is going to allow these witnesses to testify, but she first tells the defense that she could order a mistrial. She's just not going to.
I could recess this court or this trial for the rest of the day into tomorrow to give the state an opportunity to conduct the investigation that they are entitled to conduct of these witnesses. I could grant a mistrial, as your case, Ms. Kawas, that you provided to me indicates I could do. And for the record, I will state that if a deposition during a break in the trial was insufficient to cure a procedural prejudice to the state, then the trial court should have declared a mistrial. But the other cases that you provided to me do talk about the alternatives. That is brief recess, day recess, mistrial to allow the state to then rebut or get witnesses or present their trial or case, now given the testimony of these 2 witnesses who have never been listed, have never been deposed, and have not been investigated. These are all options I've been considering. I'm sure all of us can agree none of us want a mistrial. I saw you shaking your head no. We've been here now. We're into our 2nd week. Took 3 days to pick these juries and then to have this. I am not at all happy about the proceedings as they have unfolded today, because we are all supposed to operate under our rules, under our laws, under our code of professional conduct. I don't want to risk this case being retried. I am not going to strike the defendant's witnesses. I understand what I have ruled so far, but I gave the state an opportunity to talk to them. At least you have. You've deposed one. But let me say this. Their testimony shall be limited to what you've said it's limited to. If it's for impeachment or for rebuttal as to the identification of the video, that is all that is coming. You ask him pointed questions, and I expect distinct answers, or I will be sustaining objections as they're made.
And with that, the witnesses are called. And again, the audio sucks, so bear with me as I try to quickly go through these. Before calling Hakeem's sister and manager, the defense first calls one of the officers who was helping to chase the trigger man on the day of the incident. It was after the car had crashed and the trigger man had gotten out and started running.
But you were able to see this person.
From the backside. I never saw the front of the subject.
Did you see this person jump a couple of fences?
Absolutely.
He was able to evade Officer Prater.
And me.
Did you call out over the radio a description of what you saw?
Yes, sir, I did. He's approximately 5'8" to 5'10", black male, gray shirt with black sleeves and black pants.
Do you remember the build of the person that you saw?
Yes, sir. I would say fit, yeah, medium build.
Would you say, quote unquote, very fit?
I guess so, yes, sir.
Would it refresh your recollection? Take a look at the deposition. Starting line 14.
Okay, very fit. Yep. It says very fit, and before that it says rather fit, too.
So, very fit, right? And again, I'm not here to put words in your mouth. The person that you saw was rather fit, very fit. They were fit.
They were fit.
Fit enough to outrun you.
Fit enough to jump fences.
Was there anything in there in your testimony where you're saying to this jury, look, I gave that description, but I'm not sure?
Sir, I could have been wrong on the height. He could have been 6'2", 6'4". He was running.
But on that day when you wrote the report, you wrote it and that's what you believed it to be, right?
I believed it to be. He could have been 5'4", but he was running.
On cross, the state emphasizes that this officer was never close enough to give an accurate estimate of the suspect's height.
And you don't believe that you ever got a good look at this person?
The whole time, correct. It was from the backside.
Okay. At all times, this person was running away from you.
That's correct. Yes,
It was
sir.
in a crouched running motion.
That is correct.
The next witness was Hakeem's manager, but it was on Zoom, so it was very hard to hear. But I will tell you that while he was testifying, he did say that the man on the video was not Hakeem. And after that, Hakeem Robinson's sister is called to the stand.
Knowing what you know of your brother, when you saw that video, what was your opinion of who the person was?
I immediately said, excuse my language, hell no. I was like, wow.
And how did you what was it about looking at the video and then knowing what you know about your brother that led you to come to that conclusion?
So if I can give a description of how I describe my brother, I would say that I call him fat, slew-footed, which we would say 2 left feet. I call him stocky and tallest. He's a giant to me.
Okay, and how tall are you, just to give the jury some reference?
I'm 5'4".
Okay, and so as you describe him to you, he's a giant.
Yes.
And so when you looked at this, is that what it was that, in your opinion, made you believe that it was not him?
It was, honestly, being a sibling and a sister, it was the intuition, the gut feeling of just like, almost, if you know, you know. So it was gutting, but seeing it initially, I was just like, hell no.
Okay, no further questions, Judge.
All right, cross-exam.
So, Ms. Robinson, the whole group, including Abdul Sr., Abdul Jr., and the 2 defendants, were upset about this Charles McCormick making fun of the death of Willie Addison.
We all were upset.
Yeah.
We were upset that he was dissing my dead brother, Willie Addison.
Okay. And Leroy Whitaker was upset, and Hakeem Robinson was upset.
We all were upset.
Hakeem Robinson, this was his stepbrother, I think. Correct?
Yeah, we all acted as blood.
Right, but he was like his blood brother. He was that close to Willie Addison.
Yeah, we were blood.
Okay. The defendant, Hakeem Robinson, as we sit here today, is bigger than he was in January of 2020.
Slightly, yes, but he's always been just about that size. He has picked up a slightly amount of weight, and his hair has grown, but he's definitely Hakeem that I know.
I understand that. He's put on weight since January of 2020.
Slightly, yes.
Okay. Well, you didn't tell me slightly an hour ago. You said he was bigger, and now you're changing it to slightly.
Well, you asked me, was he bigger? I clarified. Well, you said significantly, and I clarified that significantly was a big word to explain this person. So I clarified to you that he was about and slightly the same size. Because you said, did you use significant?
Yes. I'll ask a question, and you can respond, since we're in a little difficult position here. I asked you if he was significantly bigger, and you would not say that he was significantly bigger, correct?
Correct.
But then we both agreed that he was bigger today. You never said
Yes.
the word slightly, correct?
All right, he's bigger today.
Okay, so you would agree that he's bigger today than he was in January of 2020?
Yes, not significantly bigger.
Okay, well, I didn't ask that, did I?
Thank you.
Okay, thank you, Ms. Robinson. I have no further questions.
Leroy Whitaker's attorney gets some questions in, and y'all know she asked about them ages.
In terms of siblings, who's older, yourself or Hakeem?
Myself.
Okay, and if you don't mind me asking, how much older are you than him?
A year?
Okay. And Willie Addison was older than you, ma'am?
Yes, he was.
How much older than you was he? And I realize this might
5 years. It's a lot of us. We rarely remember each other birthdays and dates, and we don't. So sorry if when you ask me about these times, because it's a lot of us. So the birthdays and stuff is a little.
completely understand. But you think roughly about 5 years older than yourself?
Yes,
Leroy Whitaker is substantially younger than you, correct?
he is.
Okay. Back in 2020, Hakeem was 21 years old. Does that sound about right?
Yes, it does.
So you would have been about 22, right?
Yes.
Leroy Whitaker was 19, right?
Yes.
And so Willie, had he lived, would have been, if you were 22, he would have been about 27, 28.
Correct.
Leroy Whitaker didn't have any kind of a relationship with Willie Addison, did he?
Not from my knowledge at all.
I don't have anything further, Your Honor. Thanks.
And then both sides rested. Closings were up next, but before that happened, somebody in the courtroom was apparently live streaming the trial, and the judge was pissed.
And you all can have a seat. Court is not recessed yet. I have to inquire. Ms. Kashayla Robinson, are you present? If you will please raise your hand. Where is she? Oh, she did step out? Okay, she's not going to be allowed back into this courtroom. Her Facebook has been live streaming this proceedings and specifically live streamed this witness who asked that her face not be shown. That's why our cameras did not show her face. So that means someone in here has an electronic device that is on and functioning. And I have told everyone in here that they are not allowed to have that. So whoever has that phone and was live streaming this, you will not be allowed in this courtroom. Who has Ms. Robinson's phone? Someone obviously must have.
Once that got resolved, the state gave their closing, but because there are two juries, things got a little tricky. So Hakeem Robinson's jury was excused for the day, while Leroy Whitaker's jury stayed for his attorney to do their closing and then the state to give their rebuttal. So starting tomorrow, which is technically day 7, Leroy Whitaker's jury will begin deliberating on their case. And while that's happening, Hakeem Robinson's jury will hear the closings from his attorney, and then the state will give their rebuttal for that case, and then that jury will begin deliberating. So this verdict could get very interesting. I'm curious to see which jury is going to come back first and what each verdict will be. How long y'all think it's going to take the juries to deliberate?